Hi, I'm Karan Thapar. Over the last few years, I hope you've been watching my program, The Interview on the Wire. During that period, I've interviewed doctors, politicians, businessmen, scientists, authors, and even the occasional Nobel laureate. For me, it's been exciting. I hope it's been enjoyable for you. But these, as you know, are tough times, and if this program is going to remain bold, independent, and sometimes even defiant, then I think we need your support. At the end of the day, it's a truism, but editorial independence is best defended by the viewers. So if you would like this program to remain the way it is, forthright, outspoken, and interesting, then would you consider supporting us? All you have to do is to click on the description at the bottom. But more than anything else, I hope you will continue to watch the interview. Your viewership means an awful lot to me. Hello and welcome to a special interview for The Wire. Does the Citizenship Amendment Act violate critical articles of the Constitution? And secondly, what message has the Supreme Court sent by sitting on top of over 200 petitions challenging the Act for over or almost 5 years? Those are two critical issues that I shall take up today, and my first guest is the former Law Minister and one of the country's foremost experts on the Constitution, Kapil Sibal. Mr. Sibal, in your personal opinion, does the Citizenship Amendment Act, the rules of which were notified on Monday, violate critical articles of the Constitution?
Well, absolutely, without any doubt. Because the one fundamental thing which this Act does and the rules do is to base citizenship on the basis of religion. See, citizenship essentially all over the world is based on place of birth or birth, residence, naturalization, right? But because of the peculiar nature of the partition of India that took place, registration became a mode of actually granting citizenship as well. So the present Act, the amended Act, talks of registration, talks of naturalization, right? But that registration and naturalization will grant citizenship under the rules to those who belong to a particular community, which means religion has been made the basis of citizenship. That's never happened anywhere in the world other than in Israel.
Now, Article 14 of the Indian Constitution says, and I'm quoting, "The state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India." By excluding Muslims, does the Citizenship Amendment Act breach Article 14?
Most certainly, but why just Muslims? They exclude Jews, they exclude Ahmadiyas, they exclude Hazaras, all those people who apparently are persecuted in those countries. So therefore, why just limit it to Muslims? It excludes all other communities also who are entitled on this basis to actually come to India and say, I too was persecuted and grant me citizenship.
But your critical point is that by excluding Muslims, Jews, and as you say, Hazaras and Ahmadiyas, the Citizenship Amendment Act is breaching and violating Article 14 and the critical constitutional requirement for equality under the law.
Why? Absolutely. But why have they excluded, people, Hindus persecuted in other states as well? Why have they chosen Afghanistan, Bangladesh, and Pakistan?
I'll come to that in a moment's time. I'll come to that in a moment's time. But let me ask you one more question about the extent to which the Citizenship Amendment Act violates our Constitution. Now, as you know, the preamble of the Constitution declares India to be a sovereign, socialist, secular, democratic republic. Does the Citizenship Amendment Act breach the preamble's commitment to secularism?
This government since 2014 has no commitment to secularism, as we've seen not just by this act, but several other acts since 2014. So forget about this. This government doesn't believe in secularism. Its votaries openly say that they are looking for a Hindu Rashtra.
In other words, not just the Citizenship Amendment Act, but the government itself and its policies repeatedly breach the preamble's commitment to secularism. That's what you're saying.
Absolutely, without any doubt.
Let's then come to those points that you were making, because I think they're particularly important and need to be taken up specifically one by one. The Act is designed to give citizenship to people who are discriminated on grounds of their religion in 3 countries: Pakistan, Bangladesh, and Afghanistan. Can the choice of those 3 countries rather than any other country be questioned on constitutional grounds? As you pointed out, as a result, the Act ignores the plight of Rohingyas in Myanmar. It ignores the plight of Tamils in Sri Lanka. Both of those communities are discriminated against, and both of those countries are neighbors of India.
Absolutely. And in fact, the fact of the matter is that the Tamilians are Hindus as well. So that's the other issue. If Hinduism is the basis, these Tamilians are Hindus too, who've been residing there and who would like to come to India, right?
But tell me, is that an inconsistency or is it actually a constitutional breach? Which of the two?
Both. It's both. I mean, how do you pick up only these 3 countries? And quite frankly, Karan, this is all politically motivated. Remember the rules, the Supreme Court did not grant stay because the government 4 years ago told the Supreme Court, we've amended the Act, but we have not yet brought the rules into force. 4 years later, they bring the rules into force just before the 2024 Lok Sabha election. So the motivation is quite clear.
In fact, it's not just that they brought the rules into force literally a few days or weeks before the 2024 elections. They also chose to do so on the first day of Ramzan. That is another pointed message they were sending.
This is not a fair way of dealing with the people of this country. This is trying to tell this country that, look, we have a political agenda and we will use the law to further that political agenda.
Now, even if you just focus on the 3 countries that the Act restricts itself to, those 3 countries are Afghanistan, Bangladesh, and Pakistan, the Act still ignores the plight of Ahmadiyas from Pakistan. It ignores the plight of Hazaras, who are Shias from Afghanistan. And many people will tell you, many experts, by the way, that the Pakistani Ahmadiyas face as much, if not greater, discrimination as Hindus and Christians in Pakistan. And the Afghan Hazaras face as much, if not greater, discrimination as Hindus and Sikhs in Afghanistan. So by ignoring these 2 communities in either of the 2 countries, once again, is the Act being discriminatory and breaching our constitutional requirement of equality and fair treatment?
It's clearly discriminatory, Karan. There's no doubt about it. But I have another issue here, which perhaps you may not have raised or may not raise. And the issue is that these people came to India and under the law, because they didn't have papers, were illegal immigrants, right? Now, if they were illegal immigrants, and if they came to India on the ground that they were being persecuted, then they must show as to when they were persecuted, how they were persecuted, and why they came to India because of that persecution. Now, the Act and the rules don't ask them to show any of that. This is a legal assumption that is being made that they were persecuted without any factual basis. In other words, you are granting to illegal migrants, you are granting citizenship to other illegal migrants because of their religion. You are not going to grant citizenship. That's a very serious issue.
You're making a very important point. You're saying purportedly, the Act seeks to grant citizenship to people who've been discriminated on religious grounds in the countries where they came from, but the rules do not require that they have to show where they were discriminated, how they were discriminated, when they were discriminated, and who they were discriminated by. In other words, the rules do not establish what is the premise and basis for granting the citizenship.
Neither the Act nor the rules. Nothing. They just say you have to show the country of origin where you came from, and we will, as a matter of law, assume that you were discriminated.
So this is a fundamental infirmity in the rules, isn't it?
Absolutely, without a doubt.
Now, let me pause at this point and put to you something that will have occurred to the audience. Hearing our conversation so far, the audience will say there are multiple levels at which The Citizenship Amendment Act violates our Constitution. It violates Article 14. It violates the preambular commitment to secularism. The rules themselves are infirm and inadequate. More importantly, there is a violation by simply focusing on 3 countries rather than other countries. And there's a violation within those 3 countries in excluding either the Ahmadiyas from Pakistan or the Hazaras from Afghanistan. In other words, at multiple levels, not 1 or 2, but at multiple levels, this act violates critical requirements of our Constitution. Would the audience be right in coming to that conclusion?
100%, without a doubt. And remember, these are not the only basis of persecution. There are several layers of persecution that happen. You may be a transgender, you may be,
homosexual.
Yes, exactly. I mean, persecution is not something that you can put in a straitjacket. There will be multiple reasons for persecution. If persecution is the basis, then this category of people based on their religion is completely violative of Article 14.
Absolutely. You're saying there are multiple types of persecution. This act only focuses on one type, and even on that one type, religious persecution, it focuses inadequately and with discrimination, but it ignores other types of persecution, persecution of transgenders, persecution of homosexuals, persecution of women as women. All of that is ignored. Therefore, it's very selective and very arbitrary in the persecution it focuses on. That is another infirmity in the act. Is it also a constitutional problem?
Absolutely. It's a serious constitutional problem. Because you see, and the fundamental flaw, according to me, in the act and the rules, is that you are attributing citizenship on the basis of what religion you have. This has never happened in the world.
Then let me put this to you. We have identified multiple levels, and I cannot repeat that sufficiently, multiple levels at which this act violates the critical articles and stipulations and requirements of our Constitution. Therefore, let me ask you, challenges against this act have been lying with our Supreme Court since 2019. Almost 5 years have gone by. The Hindustan Times and the Indian Express have both said there are over 200 such challenges. Not one of them has been heard so far. What message is our Supreme Court sending out by sitting for almost 5 years on over 200 challenges to an act that you've now established vitiates our Constitution extremely badly? What message is the Supreme Court sending out?
Karan, what had happened was, as I told you, that the government said to the court that, look, we're not bringing the rules, so there's no point in now allowing this challenge to go further. As and when we pronounce upon the rules or we formulate the rules, that you can hear the matter. But what they've cleverly done is they have done it just a few days before the election. So,
but hang on a second. If the argument you're presenting is correct, and I will assume that it is, that the government said to the Supreme Court, don't rush to hear any challenges against the act until we formulate the rules. And since the rules weren't formulated for almost 5 years, the Supreme Court didn't move either. Now that the government has moved, what stops the Supreme Court moving equally quickly and expeditiously?
Shouldn't. In fact, what the Supreme Court should say ideally, that if you have waited for 5 years, you can wait for another 4 months.
So you're saying that the response from the Supreme Court should be an order to the government that we stay the rules. Is that what you're suggesting?
And if you don't stay the rules, you can say nothing will be done under the rules till such time as the matters are heard after in July or sometimes in August.
In other words, you're saying the Supreme Court should either stay the rules or should issue an order that nothing will be done under the rules until we hear the matter.
Because there's a whole process that has to be followed.
What are the chances that the Supreme Court will take either of those 2 steps, both of which, I should add, would be seen as a huge rebuff, if not a slap in the face of the sitting government? So what are the chances that the Supreme Court will either order a stay on the rules or say to the government, no action should be taken under the rules until we hear the substantive challenge that lies before us? What are the chances either will happen?
Your guess is as good as mine.
But you know the Supreme Court, you know the judges, you know how this court has worked in the last 5 years. Therefore, give me your considered opinion.
Your guess is as good as mine.
In other words, you don't have great confidence the Supreme Court will take either of those two actions.
I didn't say that. I didn't say that.
Let
Look,
me.
I want to make one statement. If this government really wants a Hindu Rashtra, they should say so. I have no problems with that. But I think the agenda of any government as to where they want to go should be clear. They should not sort of, in a creeping fashion, bring about a change in our polity without publicly stating what they want.
To be fair, Mr. Sibal, this is not the first instance when, to use your phrase, in a creeping fashion, the government has tried to Hindutva-ize the country or the constitution or its policies. It's done it at multiple levels right through the last 10 years.
They should publicly state it. I think, I have no problems with that.
But let's not get sidetracked. Let's not get sidetracked into a question of what would be the honest way of the government handling its policy of Hindutvaization. Let's come back narrowly to our focus on the manner in which the Supreme Court is responding to over 200 challenges that have been with the Supreme Court for over 5 years against the Citizenship Amendment Act. Now, the rules of the Act have been notified, and presumably, unless the Supreme Court takes the action that you spoke about a moment ago, citizenship will soon be conferred under those rules on people. Therefore, if that were to happen, have those petitions, 200 and more, challenging the Act, become infructuous? Or will they at that point become infructuous?
No, they're not infructuous at all. I mean, if they are heard today and they are decided upon today, nothing, the rules will be struck down or the Act will be struck down on the basis that we have discussed. So that's not an issue. Certainly the petitions are not infructuous.
I'll tell you why I ask. Is there a danger that the petitions will become infructuous once citizenship is conferred under the rules that have now been notified?
That takes time.
Then you will be not just striking down the Act if that step is taken, but you'll also have to reverse the citizenship that's been granted.
This will take time, Karan. It won't happen tomorrow. I think this is just a message being sent because there are layers of scrutiny that have to happen, and ultimately the power is with the central government. So I think that their forms have to be filled, and there is a.
I take your point, Mr. Sibal. Conferring citizenship under the new rules will take time, but equally, we have no idea how much time the Supreme Court will take in deciding to hear the case. They haven't heard the case for almost 5 years. They could take another 5. We've no idea when they'll do it.
I don't think so. I have confidence in the Supreme Court that they will hear it very quickly.
I'm glad you have confidence. Many others that I've been talking to don't share that confidence, but let me leave it there. My last question. In the case of Article 370, when questions were asked about the Supreme Court delaying hearing the challenges brought against that abrogation, the court famously said, we can turn the clock back if need be. Can the clock be turned back in this case? I'm talking of the Citizenship Amendment Act.
No. The question doesn't arise, Karan, for the simple reason that by the time citizenship is granted, I am sure the Supreme Court will hear the matter before that happens. Once that happens, then of course you have to make each citizen a party to the proceeding, and that's such a cumbersome process that it would be difficult to turn the clock back. Where you're right on that.
Tell me something. Everything hinges upon your confidence that the Supreme Court will hear this matter fairly soon. And you also believe it will hear the matter before citizenship is granted. How confident are you of that?
I'm very confident.
Can I ask?
Because the fact of the matter is the government made a statement.
On what basis are you confident?
Because the government itself made a statement that the matters can be heard as and when the rules have been put in place, have been formulated, and people are entitled to move applications for citizenship. Once the government makes a statement, and now that the rules have been framed, then obviously the court will have to take up the challenge. So I'm quite sure that this will happen.
All right, Mr. Sibal, let's leave it there. Thank you very much for joining me, and thank you very much for explaining in such meticulous detail the multiple levels at which the Citizenship Amendment Act violates critical aspects and articles of our Constitution. And thank you also for your confidence that the Supreme Court will act, and that if it does act and it does strike down the Citizenship Amendment Act, the clock can be turned back.
I can't say whether it will strike down or not strike down, but
I said
I'm confident that it will hear the matter.
Absolutely. I said if it strikes it down, the clock can be turned back. Mr. Sibal, thank you very much indeed. Take care. Stay safe.
Thank you.
I'm now joined by one of India's top lawyers, the former president of the Supreme Court Bar Association, Dushyant Dave. Mr. Dave, in your personal opinion, does the Citizenship Amendment Act, the rules of which were notified on Monday, violate critical articles of the Indian Constitution?
Well, the answer to this is extremely difficult to give. Frankly, the amendment which was made in 2019, which allowed certain minority community members from Hindu, Parsi, Christian, Buddhist, and Sikh religions from 3 countries to come in, to that extent, which has been now notified in March of 2024, the rules. To that extent, I would say that it doesn't appear to be unconstitutional to me, because there is a reasonable classification in that these are the people who really had left or were part of the original larger India, which was Afghanistan, Pakistan, and Bangladesh together with India. So to that extent, Parliament seems to have made some kind of a differentiation. Now, question is whether this differentiation is based on an intelligible criteria or not. To my mind, it can be defended that it is on intelligible criteria and therefore it is justified. Keeping out the Muslim community from that is a larger question, but I don't think, really speaking, as the Act stands, 2019, I mean Citizenship Act as amended in 2019, read with the rules which are now published, I think it would be very difficult to say that it is really unconstitutional on the face of it.
Let me ask you 2 specific questions. Article 14 of the Constitution says, and I'm quoting, the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. By excluding Muslims specifically, does the Citizenship Amendment Act breach Article 14? Many people believe it does. What's your opinion?
Well, it's really speaking, the the Article 14, certainly, as you very rightly point out, is a very important, omnipresent article in the Constitution, and it definitely says that state cannot discriminate on any ground whatsoever. So to that extent, you are right. But we are dealing with a question where there is a case of people who are allegedly who are illegal immigrants, and it is therefore very not very clear whether Article 14 will be made applicable qua them. Supreme Court has indeed extended Article 21 to foreigners, but it has so far, it's a question which will have to be seen whether, really speaking, the protection of Article 14 will apply to alleged illegal immigrants. We are dealing with today a situation where we are dealing with these people who have come from outside. We are not dealing with Indian citizens as yet, because NRC in India is not sought to be implemented.
I understand. What you're saying is that whilst prima facie, it looks as if the Citizenship Amendment Act of 2019 breaches Article 14. The question is, does Article 14 apply to illegal citizens who happen to be in India? Your feeling is that the Supreme Court has not extended its application to illegal citizens, and therefore it may not apply to them. And therefore, since the amendment only has to do with illegal people, it may not apply to them.
As I said earlier, I mean, on the face of it, the Amending Act of 2019 it's very difficult to say whether it is unconstitutional. I think the court will have to go into it. It requires a very, very detailed argument before the court, and we'll have to see what would be the court's approach. I doubt on the face of it, the court will be able to hold that it is unconstitutional. See,
Let me ask you a second question. This time, not about Article 14, but about the preamble of the Constitution. As you know better than me, the preamble specifically says that India is a sovereign, socialist, secular, democratic republic. Does the Citizenship Amendment Act breach the commitment in the preamble to secularism?
No, it doesn't. I agree. And there is no doubt that keeping Muslim out is a very, very serious I would say, omission on the part of the parliament. There is no doubt about that. Question is, that whether this is an intelligible criteria or not. That's the question. Yes, it does on the face of it discriminate. And therefore, to that extent, it is, I would say, I may not call it unconstitutional, but I will certainly say that it is illegal, and I would certainly say that it is unjust.
Okay, illegal but not unconstitutional necessarily. Is that a contradiction?
Yes, there is a contradiction, because illegal in the sense that yes, it may appear it may not violate a constitutional provision, and yet it can be violative, because the statute which Parliament has brought, one can say that yes, Muslims should have been included, and they have a legitimate expectation to be included in that. So to that extent, it's a debate which will have to be really expanded in a very larger legal sense.
Let me ask you two specific questions. There is a view that by focusing the act only on illegal people who've come from three countries, Afghanistan, Bangladesh, and Pakistan, and excluding all other countries, including, for instance, Myanmar, from where there are Rohingyas who are suffering, excluding Sri Lanka, where there are Tamils who are suffering, that this is discriminatory, that this is inconsistent, and therefore it is wrong. Do you share that view, or do you disagree?
No, I don't share that view at all. Because, first and foremost, unless we are signatory to the International Refugee Convention, it becomes very difficult. It's for a country to decide whether it really wants to take this. We are already 1.4 billion people, and we really don't have the resources to have more and more people coming into our country. It's not like United States of America, which has the huge land mass available, and which has huge resources which can accommodate millions of people coming in from South America. We don't have that situation. So in its wisdom, if Parliament decides that we want to keep out certain people, yes, it can be done. So these are all extremely, I would say, it is a political message which the ruling party is giving, that we do not want Muslims to enter this country.
I understand. Once again,
but I would say that there is no obligation on the part of the Parliament to include everybody who claims that he should be entitled to be made a citizen of India.
So what you're saying, in essence, is that excluding countries like Myanmar and Sri Lanka and only focusing on three countries, Afghanistan, Pakistan, and Bangladesh, may feel morally inconsistent. It may raise questions about logic, but it's not unconstitutional.
Yes, absolutely.
Let me ask you a second specific question. Many people say that this act does not cover the Ahmadiyas in Pakistan, nor does it cover the Hazaras who are Shias in Afghanistan. And clearly, the Ahmadiyas in Pakistan suffer as much discrimination as Hindus and Christians in Pakistan, but they are not covered. Similarly, the Hazaras in Afghanistan suffer as much discrimination as Hindus and Sikhs in Afghanistan, but they are not covered. Again, is their omission unconstitutional? Or is it like the earlier question, morally questionable perhaps, but not unconstitutional?
Yes, it is morally questionable. It is purely political. But I doubt it can be, characterized as unconstitutional per se.
So to sum up your position, you said, and I think I'm quoting you correctly, the answer to the question, is the Citizenship Amendment Act violative of the Constitution? You said it is extremely difficult to say yes. You say it doesn't appear to you to be unconstitutional. It may raise questions of politics. It may raise questions of moral equivalence, but it does not necessarily become unconstitutional. Have I summed that up correctly?
Yes, that's correct. Karan, the real problem is going to be, and perhaps you are aware of that if the NRC, National Register certificate, is applied to the whole country. Presently, it is only being considered in Assam, because Assam has unique problem on account of influx of the Bangladeshis before 71 and post 71. But if NRC is applied across the country, and that unfortunately is under the rules of 2003, when the UPA was in I think power at that point of time. I don't know which government was in power in 2003. No, it was the Vajpayee government. Anyway, so these are 2003 rules under which it was brought in. Now that exercise will certainly create a very, very serious situation. And carrying that exercise under the rules of 2003 will be definitely raise serious constitutional questions, because you are now putting.
But the NRC is different to the CAA.
It is undoubtedly it's different.
Let's not mix the two. Your
No,
position
but
on the
what I'm
CAA, your position on the CAA is that you do not believe it is unconstitutional.
Yes. What I'm trying to say is that today there is a lot of misgiving in sections of people, which is justified, that NRC certainly will be a problem, but CA as it presently implemented, particularly in the light of this March to 2024 notification per se, is really not something which is going to create any serious problem for people in this country, especially the minority community. And I would say that to that extent, both the ruling party and opposition must give a correct message to the country that this is not really seriously going to take away citizenship of people.
You're making an important point, but I want to just reiterate the earlier point you made. At the moment, you just said that the CAA and the rules to implement the CAA are not going to create a serious problem for anyone living in this country. It won't create a serious problem for anyone who is presently a citizen of the country. It's not depriving them in any way of their citizenship. But the bigger point you made earlier, I'm reiterating it, is that you do not believe the CAA violates critical articles of the Constitution. It does not, in your opinion, violate Article 14. It does not violate the preambular commitment to secularism. That's the important point. And in the light of that point, let me then come to the second big issue I want to raise with you. There are over 200 challenges to the CAA arguing that it is unconstitutional, sitting with the Supreme Court. They've been there since 2019. For almost 5 years, the Supreme Court hasn't heard those challenges at all. We have no idea when the Supreme Court will take up those challenges. Does that send out a disturbing message to the country from the Supreme Court? Or in the light of what you said, that you don't believe the CAA is unconstitutional, is it understandable that the Supreme Court is not rushing to hear these challenges? Which of the two?
No, I don't think. I think Supreme Court should have heard these matters as quickly as possible. Whether the court will uphold the laws or declare them unconstitutional is not the issue. Issue is that if people have raised serious challenges against the validity of these provisions, the court has an obligation to hear this matter, because ultimately the members of the minority community, and they are almost 17% of our population, if they feel anxiety, if they feel serious concerns about their very existence in this country, then court has an obligation to at least quickly take up the matters here and decide. Court could have done whatever it wanted to do, but I think that's where one feels little disappointed that court is not very, I would say, quick. It has to show the alacrity which is expected in matters of this kind of. This raises serious public interest.
I understand your point. You're saying regardless of whether the court upholds the CAA or doesn't, and you believe, in fact, that the CAA is not unconstitutional, but regardless of that, the court should have heard these matters with alacrity because they are causing disquiet. They are disturbing 17% of the country's population. You cannot delay and tarry when that is the case. That's the point you're making.
Absolutely, absolutely.
But then tell me this. Now that the rules of the Act have been notified, pretty soon hereafter, maybe in months, maybe in a year, the first few people will receive citizenship under this Act. At that point, if the court still hasn't heard the challenges, do they become infructuous? Because then people will have already got citizenship.
No, they may not be, court has wide powers. Court can, what is the position today? The legislation has positively, agreed to grant citizenship to certain groups of people. Now they have excluded the Muslims from these 3 countries. Okay, the court has a power to extend that. There is a precedent where court can say that this is discriminatory, this violates Article 14, but instead of striking down the benefit which is given by the parliament to few group, we extend this benefit to those which are denied the benefit. So court has ample power to do complete justice between the parties.
But you don't think the challenges will become infructuous in the weeks and months ahead when citizenship is conferred under the Act? That you don't think follows?
No, I don't think it can become infructuous. It may only delay, the time for, those excluded group to really apply for citizenship and get the citizenship, should the court hold in their favor.
Does it therefore follow, Mr. Dave, that whenever the court hears the challenges to the Citizenship Amendment Act, it can, if it wants, turn the clock back, even though by then citizenship has been granted to some people?
Absolutely, it can, and I'm sure it will be persuaded to do so if the court thinks that the law is unconstitutional.
One last question. There are some people who say, because the challenges haven't been heard, and because it is possible, you may disagree, but because it is possible that the Supreme Court may strike down the CAA as unconstitutional, therefore today, the Supreme Court should stay the rules that were notified on Monday, or at least issue an order that no action should be taken under those rules. Would you agree with that?
Well, yes and no. We all know that these rules are notified for political reasons. Ultimately, the ruling party needs something to, to pacify the Hindu majority in this country. So, there are two ways it works. That yes, the Hindus and the Buddhists and the Christians are all welcome, but the Muslims are not welcome. So it's a two-pronged strategy of the ruling party. But having said that, it's for ultimately Parliament to do what it wants to do.
But what about the court? Should the court say, because the challenges are yet to be heard, and because it's potentially possible we may strike down the act when we hear the challenges, therefore, please stay the rules, or at least don't act under the rules? Would that be
unfortunately, I'm not sure.
A sensible position for the court to take?
Yes, but unfortunately, I'm really not sure whether at any stage from 2019, court made any order or observation requesting the government not to proceed with the matter. So if the court didn't stay further action, including notification of the rules, government was well within its right to effectuate the rules. Yes, I'm sure the petitioners can go to the court and try and persuade the court. So it's for the court to decide what it wants to do.
But you're saying something very important. You're saying because the court has not, since 2019, given any indication that it would like the center or the central government to delay or stay the rules, now that the rules have been notified without the court denying the right to do so, it would be inconsistent of the court to suddenly say, stay the rules. In other words...
No, court can still grant stay. Court can still grant stay because the...
Then what's your answer? Give me your answer. Should it stay the rules and also stop action under the rules, or should it not?
Look, let me put it this way. The cause of action has arisen on 10th of March 2024 when the rules are effectuated. So petitioners before the Supreme Court can certainly seek stay. Whether the Supreme Court will grant stay or not is not for me to speculate.
That's what I'm asking you. What's your opinion? You must have a personal opinion.
No, I can't speculate. It's for the Supreme Court to decide what it wants to do. And
all right,
for the petitioners to persuade the Supreme Court.
All right, Mr. Dave, thank you very much for making time for me. And let me repeat what I believe is the most critical thing you have said. You began by saying it is extremely difficult to give a clear answer to the question, does the CAA violate the Indian Constitution? But you then ended up actually fairly categorically saying you believe it does not. It may be morally inconsistent, it may be political, but you clearly said you don't believe it is unconstitutional. And I thank you for that clear and forthright answer. Take care. Stay safe.
Thank you, Karan, as always.
Hi, I'm Karan Thapar. Over the last few years, I hope you've been watching my program, The Interview on the Wire. During that period, I've interviewed doctors, politicians, businessmen, scientists, authors, and even the occasional Nobel laureate. For me, it's been exciting. I hope it's been enjoyable for you. But these, as you know, are tough times, and if this program is going to remain bold, independent, and sometimes even defiant, then I think we need your support. At the end of the day, it's a truism, but editorial independence is best defended by the viewers. So if you would like this program to remain the way it is, forthright, outspoken, and interesting, then would you consider supporting us? All you have to do is to click on the description at the bottom. But more than anything else, I hope you will continue to watch the interview. Your viewership means an awful lot to me.